One wrong word during a traffic stop and you're handing over your rights, giving officers everything they need to search your vehicle, seize your firearm, and build a case against you. Right now, law-abiding gun owners are being arrested at traffic stops because they didn't know 4 simple phrases that force officers to either let you go or prove they have legal grounds to detain you. Today, I'm breaking down the 4 critical phrases every armed citizen must know during police encounters that could mean the difference between driving away free or facing felony charges. By the end of this video, you'll know exactly what to say and what never to say to protect your constitutional rights during any traffic stop. Here's why this matters right now. Last year alone, over 400 concealed carry permit holders lost their gun rights after traffic stops went wrong. Not because they were criminals, but because they said the wrong thing at the wrong time. Courts ruled against them because they failed to use specific legal language that's required to protect your rights. This is happening to gun owners just like you every single day. Number 1. Am I free to leave? This is the single most powerful question you can ask during any police encounter, and 99% of gun owners never use it. Here's what you need to understand. Police encounters fall into 3 legal categories: voluntary contact, investigative detention, or arrest. Most gun owners never figure out which category they're in, and that confusion costs them everything. Officers are trained to keep things deliberately vague because the longer you stay, the more evidence they can gather against you. Picture this scenario. You're driving home with your legally owned firearm in the vehicle. The officer pulls you over for a broken taillight. He checks your license, runs your permit, writes the ticket, and hands everything back. Then he casually says, "So where are you headed tonight? You've been out at the range." Most gun owners answer because they think they're being polite. Big mistake. The moment that ticket is in your hand, the officer's legal authority to detain you is over. This comes directly from the Supreme Court case Rodriguez versus United States, 2015. The court made it crystal clear. Officers cannot prolong a traffic stop beyond the time needed to handle the original traffic violation, not even by 5 minutes. So when that officer starts making small talk after the ticket is written, you are no longer legally required to stay. You're in what's called a voluntary encounter now. That's when you say, "Officer, am I free to leave?" If he says yes, you leave immediately. Don't answer another question. Don't explain where you're going. Don't mention your firearm unless your state requires immediate disclosure. You simply say thank you and drive away. If he says no, now you know you're being detained, which means he must have reasonable suspicion that you're involved in criminal activity. Not a hunch, not a feeling. Specific, articulable facts that he must be able to justify in court. Here's the psychology behind this question. Officers hate it because it forces them to make a decision on camera. Their body cam is recording everything. The moment you ask, "Am I free to leave?" they must either release you or admit they're detaining you, which they have to justify later. This question protects you whether they say yes or no. Wrong way. Officer hands you the ticket and says, "You're all set. Hey, is that a gun case in your back seat?" You answer, "Yes, sir. I was at the range earlier." Now he's got you talking. He asks what kind of gun. You tell him. He asks if it's loaded. You explain your state's transport laws. Every single answer gives him more information to use against you. Right way, officer says, "You're all set," then starts asking questions. You immediately respond, "Officer, am I free to leave?" He pauses and says, "I just have a few quick questions." You repeat calmly, "Am I free to leave?" or "Am I being detained?" Now he's stuck. If you're free to leave, the conversation ends and you drive away. If you're detained, he must justify it on camera with specific facts. The beauty of this phrase is that it works at any point during the stop, after he returns your documents, after he's asked a few questions, even 20 minutes into the encounter. The moment you ask, "Am I free to leave?" you're forcing him to make a legal determination that protects your rights. One critical thing for armed citizens. In most states, if you're detained and carrying a firearm, you must disclose that information when asked. But during voluntary contact after the stop is completed, different rules may apply depending on your state. Know your local duty to inform laws. But here's the key. You still control whether that voluntary conversation continues by asking if you're free to leave. Next critical phrase that stops officers from using your silence against you in court. Number 2, I plead the fifth. Most gun owners think staying silent is enough to protect them. It's not. Your silence can be used as evidence of guilt unless you explicitly invoke your Fifth Amendment right with these exact words. In 2013, the Supreme Court made a devastating ruling in Salinas versus Texas. They decided that your silence during police questioning can be used against you at trial unless you verbally invoke the privilege. If you just stay quiet without saying the magic words, prosecutors can tell a jury. Notice how he refused to answer when asked about the gun. That's because he knew he was guilty. Here's what happened in that case. Genevieve Salinas was questioned by police about a murder. He wasn't under arrest. He wasn't in custody. He voluntarily answered questions for almost an hour. Then the detective asked, "Will the shotgun shells from your house match the ones we found at the crime scene?" Salinas went completely silent. At trial, the prosecution used that silence as proof of guilt. The Supreme Court said that was perfectly legal because Salinas never explicitly invoked his Fifth Amendment privilege. This is the rule that could save you from a felony conviction. You must verbally say the words, "I plead the Fifth," or "I invoke my right to remain silent." It's not enough to just stop talking. You must announce that you're exercising your constitutional right. Officers are specifically trained to exploit your silence. If you don't invoke the privilege properly, they'll note in their report, "Suspect became evasive when questioned about the firearm. Displayed guilty behavior." Then at trial, the prosecutor stands in front of the jury and says, "The defendant went silent when asked if the gun was loaded." Innocent people don't act that way. Picture this scenario. The officer pulls you over, discovers you're carrying concealed. Start asking questions beyond basic identification. "Where were you planning to use this gun tonight? Why do you need to carry in this neighborhood? Have you been drinking? Any drugs in the vehicle?" You feel the pressure building. You stop answering. That's when you've just made a critical mistake. The officer writes in his report, "Driver became uncooperative and evasive when questioned about the firearm, consistent with someone engaged in criminal activity." Now you're facing charges, and the prosecutor uses your silence to convince the jury you're guilty. Right way, officer asks, "Why are you carrying a gun in this neighborhood? Planning to use it tonight?" You respond clearly, "Officer, I'm invoking my Fifth Amendment right to remain silent. I'm not answering questions without my attorney present." He pushes back. They always do. "Why are you lawyering up? What are you hiding?" Innocent people don't need lawyers. This is manipulation. You simply repeat, "I plead the Fifth. I'm not answering any questions." Now your silence is protected. You've clearly invoked a constitutional right on camera. The prosecutor cannot tell the jury that your silence proves guilt. You've cut off that entire line of attack. Here's the key point for gun owners. Once you invoke your Fifth Amendment right, you must stick to it completely. Don't answer one more question. Don't try to explain yourself. Don't say, "Well, I just don't want to talk about that one thing." The moment you start answering questions again, you've waived the privilege. Officers will keep asking questions after you invoke. They'll try different approaches. They'll act friendly. They'll act threatening. They'll tell you it'll go easier if you just cooperate. Let them talk. You've done your job. Just keep saying, "I've invoked my Fifth Amendment right. I'm not answering questions. I know it's uncomfortable. You're a law-abiding citizen. You're a legal gun owner. You've done nothing wrong." Every instinct tells you to explain, to prove your innocence, to show you're one of the good guys. Resist that instinct. The roadside is not the place to prove your case. That's what courtrooms and lawyers are for. Remember this phrase word for word. "I plead the Fifth," for words that could mean the difference between going home and going to jail. But there's an even more powerful phrase that ends police questioning immediately. Number 3, "I want a lawyer." This phrase ends interrogation immediately, but you must be crystal clear and unambiguous, or officers will keep questioning you anyway. You can invoke your Sixth Amendment right to counsel at any time during any police interaction. Once you clearly request an attorney, all questioning is supposed to stop by law. But here's where most gun owners make a fatal mistake. They're not direct enough. What doesn't work? "Maybe I should talk to a lawyer." That's not clear enough. Officers will keep questioning. "I think I might need a lawyer." Still not clear. "Should I get a lawyer?" You're asking them, not invoking your right. All of these vague statements allow officers to continue the interrogation. What works? "I want a lawyer," or "I'm not speaking without my attorney present." Simple, direct, unambiguous. 3 or 4 words that invoke your constitutional right so clearly that any questioning after that point becomes inadmissible in court. Here's the exact scenario that destroys gun owners at traffic stops. The officer discovers you're armed. He asks where you're coming from, where you're going, whether you've been drinking, whether there are drugs in the vehicle. You answer a few questions thinking cooperation will end this faster. Wrong. Now you're in what's called a custodial interrogation, and anything you say can and will be used against you. The officer might say, "Why do you need a lawyer if you didn't do anything wrong?" Only criminals ask for lawyers. If you've got nothing to hide, just answer my questions, and we can both go home. That is manipulation. That is a tactic they're trained to use. Do not engage with it. Simply repeat, "I've requested my attorney. I'm not answering questions." He might escalate. Once you lawyer up, "I can't help you anymore. You're making this much worse for yourself. I was going to let you go with a warning, but now I have to assume you're hiding something." something. Again, manipulation. Just repeat, I want my lawyer. I'm not discussing anything further. Real case example. Guy gets pulled over in Texas. The officer sees a gun case in the back seat and asks about it. Driver discloses he's legally carrying under his LTC. The officer claims he smells marijuana and asks, "How much weed did you get? Just tell me the truth and we'll sort this out." The driver panics and says, "Officer, I don't smoke. I had friends in the car earlier who might have been smoking." Arrest. Right there. The driver just admitted drugs were in the vehicle and other people had access to it. The officer searches, finds an old roach under the seat. Driver arrested, charged with possession, LTC suspended, guns seized. All because he answered one question instead of invoking his rights. Right way. Officer says, "How much weed you got?" Driver responds, "I'm invoking my Fifth Amendment right. I want my attorney. I'm not answering questions." The officer threatens, "Fine, I'm calling a K-9 unit. We'll be here for hours." The driver calmly repeats, "I've requested my lawyer. I'm not discussing anything further." Now the officer needs independent probable cause to search or detain you further. The driver gave him absolutely nothing to work with. No admissions, no inconsistent statements, nothing. Bottom line for armed citizens, use this phrase early, before you say anything that can hurt you. Never let an officer talk you out of requesting a lawyer. Smart people invoke their rights. Criminals try to talk their way out of situations. You're not a criminal. You're a law-abiding gun owner protecting your constitutional rights. The fourth phrase is your shield against illegal searches of your vehicle and firearm. Number 4, I do not consent to searches. This is your Fourth Amendment shield. And if you give consent, everything officers find becomes admissible in court, even if the search was completely illegal. Here's what you must understand. Consent cures all. Even an illegal search becomes legal if you consented to it. But if you clearly refuse consent and they search anyway without probable cause, that evidence gets thrown out. This is the difference between conviction and freedom. The officer pulls you over, runs your license, walks back to your vehicle. He says, "You don't have anything illegal in the car, right? You don't mind if I take a quick look?" That question is a carefully designed trap. If you say yes, he claims you consented to the search. If you say no, he claims you said you don't mind, which is consent. Either way, you lose. Only response: "Officer, I do not consent to any searches." Clear, direct, unambiguous. Watch how the dynamic changes. The officer might get aggressive. "What are you hiding? Why won't you let me search if you've got nothing illegal? You said you're a legal gun owner. Prove it. Let me see inside." Do not take the bait. Stay calm and repeat, "I'm not consenting to searches. If you have probable cause, do what you need to do, but I do not give my consent." Here's what you just did. You forced him to have independent legal justification for any search. Your refusal doesn't give him probable cause. He needs actual evidence of a crime, odor of drugs, visible contraband, outstanding warrants, something specific he can articulate in court. Drug dog threat. Officers love saying, "Fine, I'm calling a K-9 unit. We'll sit here until it arrives." This is where Rodriguez versus the United States protects you again. Officers cannot prolong a traffic stop to wait for a drug dog unless they have reasonable suspicion of criminal activity beyond the traffic violation. When he says, "I'm calling a K-9, you respond, "Officer, am I free to leave?" If the original stop is completed, he cannot legally hold you to wait for the dog. If he does, your lawyer gets the entire stop thrown out. State variations matter here. In Texas and Florida, marijuana odor is still considered probable cause for a search. But in Colorado, Maryland, and several other states, courts have ruled that smell alone isn't sufficient. If you've clearly refused consent, your lawyer has grounds to challenge the search even if the officer claims he smelled something. Before and after example. Before, officer asks to search. You say, I guess so. I've got nothing to hide." The officer spends 30 minutes tearing through your vehicle. He finds your legally owned firearms, asks why you have so many guns, questions whether you're transporting them legally, makes you late for work, leaves your belongings scattered everywhere. Anything he finds is admissible because you consented. After, officer asks to search. You say clearly, "I do not consent to any searches." The officer threatens to call backup and bring drug dogs. You repeat, "I do not consent to searches. Am I free to leave?" He realizes you know your rights. He either needs to develop probable cause right now, or he has to let you go. Final critical point: never physically resist a search. If the officer searches anyway after you've refused consent, Keep saying, "I do not consent" repeatedly. Make absolutely sure it's on the body camera. Say it clearly every time he opens a door, every time he looks in a compartment, every time he touches your property. "Officer, I do not consent to this search. I do not consent to this search. I do not consent to this search." Your verbal refusal makes that search challengeable in court. If he had no probable cause and you clearly refused consent on camera, your attorney can file a motion to suppress all evidence from that search. Case dismissed. For gun owners, this is especially critical. Officers who discover you're armed often want to inspect your other firearms, check how they're stored, and verify they're legal. Unless they have probable cause that you're committing a crime, you do not have to consent to these searches. Your carry permit is proof of legality. They can verify it's valid. That's it. "Officer, my carry permit proves I'm legal. I do not consent to any further searches of my vehicle or property." Now let me give you the complete physical safety protocol for traffic stops when you're armed. When those red and blue lights flash behind you, here's exactly what you do. Pull over safely as quickly as possible. If it's dark outside, turn on your dome light so the officer can see inside your vehicle. Turn off your engine completely. Place both hands on the steering wheel at 10 and 2 where they're clearly visible. Roll your window down only 2 to 4 inches, not all the way down. This prevents plain view searches while still allowing communication. Lock your doors. Say clearly, "Officer, I'm locking the vehicle for my safety and yours." I'll hand all the documents through the window. This shows cooperation while preventing the officer from opening your door and claiming he saw something in plain view that gave him probable cause to search. When the officer asks for license and registration, announce your movements before you make them. "Officer, my license is in my wallet in my back pocket. My registration is in my glove box. May I reach for them?" Wait for acknowledgement, then move slowly and deliberately. Narrate everything. "I'm reaching for my wallet now. I'm opening the glove box now." Officers are trained to watch for furtive movements. Anything quick or unexpected gets interpreted as a potential threat, especially when they know you're armed. Understand the difference between requests and orders. "Can you step out of the car?" is a request. You can decline. "Step out of the car" is a direct order. Under Pennsylvania versus Mims, officers can order you out of the vehicle during a lawful traffic stop. How to handle it. "Officer, are you asking me or ordering me to step out?" If he says he's ordering you, then comply, but say clearly, "For the record, I am complying under protest. My hands will remain visible at all times." You're obeying the lawful order, but you're stating on camera that you did not exit voluntarily. This preserves your Fourth Amendment protections. If he says he's asking you, you can politely decline. "I prefer to remain in my vehicle, officer." Common mistakes that destroy your protection. Mistake number 1, talking too much. Every single word beyond your 4 critical phrases helps the prosecution build a case against you. You're not being rude by staying quiet. You're being smart. Mistake number 2, trying to outsmart the officer with legal arguments. Don't argue case law on the roadside. Don't cite statutes. Don't lecture about constitutional rights. Just use your 4 phrases. "Am I free to leave? I plead the 5th. I want a lawyer. I do not consent to searches." That's it. Mistake number 3, giving consent under pressure. When an officer says, "I'm getting a warrant," that's usually a bluff. If he actually had grounds for a warrant, he wouldn't be asking for your consent. He'd just get the warrant. Stay firm. "I do not consent to searches." Mistake number 4, answering just one more question after you've invoked your rights. Once you say, "I plead the 5th" or "I want a lawyer," you must stop talking completely. Every answer after that weakens your protection and may be ruled as waiving your rights. Mistake number 5, thinking politeness requires compliance. You can be respectful and firm at the same time. "Officer, with all due respect, I'm not answering questions without my attorney present. I plead the 5th. Polite tone. Absolute boundary. Here's the truth that most gun owners never understand until it's too late. You lose your rights before you realize you had them. Courts don't care about what you meant to say or what you thought your rights were. Courts care about the exact words that came out of your mouth and whether you used the specific legal language required to invoke constitutional protections. If you don't use the right words at the right time, you lose those protections forever. These 4 phrases are your legal armor during any police encounter. "Am I free to leave?" forces the officer to justify continued detention or release you immediately. "I plead the 5th." protects your silence from being used as evidence of guilt. "I want a lawyer" ends all interrogation and protects everything you say after that point. "I do not consent to searches" makes any search without probable cause challengeable and possibly illegal. Stop this video right now. Pull out your phone. Open your notes app. Type these 4 phrases exactly as I've given them to you. "Am I free to leave?" "I plead the 5th." "I want a lawyer." "I do not consent to searches." Save that note. Title it Traffic Stop Rights. Read it before you drive anywhere with your firearm. Make these words automatic. When those lights flash behind you, your adrenaline spikes. Your heart races. Your hands shake. You cannot think clearly at that moment. You need these phrases so deeply memorized that they come out automatically. Practice saying them out loud right now. Am I free to leave? Say it. I plead the fifth. Say it. I want a lawyer. Say it. I do not consent to searches. Say it. Make these words feel natural coming out of your mouth, so when the pressure is on, they flow automatically. Remember this crucial point. Officers are doing their job. They're trained to gather evidence. They're trained to get you talking. They're trained to get your consent. That's not evil. That's law enforcement. Your job is different. Your job is to protect yourself and your family, not to prove your innocence on the roadside, not to explain yourself to make the officer feel better, not to show how cooperative you are. Your job is to use these 4 phrases: stay calm, stay respectful, and let your attorney handle everything else in court where it actually matters. The smartest people aren't the ones who talk the most during police encounters. They're the ones who know exactly when to stop talking and exactly what to say to protect their rights. Let's recap the 4 phrases that could keep you out of jail and protect your gun rights. Number 1. Am I free to leave? Forces officers to either release you or justify your detention with specific facts. Number 2. I plead the fifth. Protects your silence from being used as evidence against you at trial. Number 3. I want a lawyer. Ends interrogation immediately and protects your right to counsel. Number 4. I do not consent to searches. Makes illegal searches challengeable in court and forces officers to have probable cause. Any one mistake during a traffic stop could cost you thousands in legal fees, your concealed carry permit, your firearms, and potentially your freedom. Don't let confusion about your rights put you at risk during police encounters. Subscribe to Guns Law Guide so you never miss an update that could keep you legal and protected. I break down complex gun laws and your constitutional rights every single week so you can carry with confidence and protect yourself in any situation. Next video, I'm covering the 5 deadliest concealed carry mistakes that get legal gun owners arrested. Mistakes that happen every single day to people who thought they were following the law. You won't want to miss it.